Assalamualaikum warahmatullahi wabarakatuh to Dr. Suzy. I hope you're having a good day. My name is Izzatunnadhirah binti Azizi, and me and my crewmates Khairah Jamilah and Siti Mariam will be presenting a mini research on the topic of trespass to person, assault and battery. So I'll first start this presentation with a summary of the news. This case happened on 13 January 2020, which was earlier this year. It took place in Kampung Sri Lumpur, Mersing. The plaintiff, 24 years old, had just arrived at the house of his foster mother when he got called by the defendants. There were 3 defendants who were at the next door. The plaintiff, upon getting there, was forced to take off his clothes before he got poured by hot water and beaten by a hard object. He was then compelled or forced to ride his motorcycle to Sungai Derhaka while being followed by one of the defendants that was holding a knife. The defendants had then threatened to kill him, but fortunately the plaintiff had managed to set himself free and went home, and he was straight away referred to the hospital. As a result of the attack, the plaintiff had suffered a serious scald, which is hot water burn, on several parts of his body, and his right index finger was also broken. Next, moving on to the summary of the first case, which is the case of Ng Choi Au and another, and Ng Ah Jem, alias Ng Kim Piao and another. It's a case of 2008, Malay Law Journal Unreported 210. This is actually a case regarding battery. The appellant or the plaintiff in this case had made an appeal against the decision of the previous sessions court, which was held to be contributory negligent, and her claim for exemplary damages, aggravated damages, and psychological injury were refused. In this case, the appellant and the respondent were immediate neighbors within the same housing estate. The appellant was beaten by the respondent with a long piece of wood while she was on her way back home from her usual morning jog in their neighborhood area. The respondent actually gotten angry because the appellant had told him to tie their dogs, and she said, "Rich people, don't be arrogant and do so much evil. Be careful of retribution." So getting provoked by this appellant's word, the first respondent had gone to beat her, joined by the second respondent. The beating did not even stop even after the appellant's husband came to help and threatened to call the police. Only after the appellant's son, which was the second appellant, came to attack both respondents with a piece of rattan, that the beating stopped and both respondents retreated. As a consequence of this action, the appellant had suffered injuries to her hand, while her son got injured on his head while trying to help his mother. So the court in this case held that the respondents were wholly liable for the injuries suffered by both appellants. So the issue of contributory negligence was not raised and was not applicable in this case. Second, the appellants were entitled for aggravated damages amounting to 15,000 ringgit and psychological injury of 10,000 ringgit. However, her appeal for exemplary damages was not granted. So the decision was made based on several grounds. The first one is that the words uttered by the appellant were just ordinary words and not provocative. The judge said that the words was not a valid justification for the respondents to conduct themselves in the manner they have conducted themselves against the appellant, which was beating the appellant with a piece of wood, and those words was not amounting to an invitation to fight. Second, the respondent armed himself with a piece of wood, which means that the act was premeditated and not an act of defense from the respondent. This act here actually shows the wickedness and malicious intent of the respondent, showing that the hostile intention was apparent in this case. Third, exemplary damages was not granted due to the fact that the appellant did not fall in any category of cases where exemplary damages may be allowed.
Assalamualaikum, Doctor. I'm Khairah, and I will proceed with the summaries of our second case, which is the case of Tan Ken Ho and Poh Kian Chong, 2008 MLJ1. So basically, this is an appeal case where plaintiff's application for damages against defendant for assault and battery was dismissed by the lower court. Hence, due to being dissatisfied with the decisions, the plaintiff made an appeal to the High Court. So the parties in this case, the appellant, which is the plaintiff, the owners of the cafe, and the respondent, which is the defendant, was a taxi driver. So basically here, the appellant was assaulted and beaten by the respondent in front of his cafe. So the facts of this case is that the appellant used to park his car behind his shop at the taxi parking space, because considering that that taxi parking space was right behind his shop, so he illegally parking to that space. However, on some time, which is on 3rd May 2005, at about 12:30 p.m., the appellant discovered that his tire was punctured, and he asked his employer about the tire. And before his employer got to answer, suddenly the respondent shouted to him, "Are you talking about me?" in Mandarin. And before the appellant himself got to answer, suddenly the respondent punched right into his right eye till the appellant fall down to the ground. And even after that, the respondent kept kicking and punching all over the appellant's body until the appellant's wife realized that situation and came over to stop them and rushing to the police station to lodge a report. And however, the police told them to get a treatment at the hospital first. So the issue which has been arises in this case is whether the appellant entitled for damages against the respondents for assault and battery. And the court held that the appeal was allowed with the cause the appellant was entitled for damages against respondent for assault and battery. The reason behind the decisions of the court is that first, the appellant, which is the plaintiff, managed to prove with the medical evidence and other witnesses, his employer, that he sustained injuries as a result of the assault, which is the judge said that the fact that the plaintiff sustained injuries during the incidents is corroborated by the medical evidence, and his evidence that it was defendant who caused them is corroborated by plaintiff witness 6, which is his employer. And the second, the court also mentioned that the appellant's wife role was merely to try to stop the assault and to bring the appellants to the police station then hospital. It was not contended that it was the only reason why the defendant stopped attacking him. And the court also emphasized on the issue of whether the defendant assaulted the plaintiff causing the injury rather than the issues of the role of the appellant's wife in this case and the credibility of the witnesses in this case, which is the employers of the appellants.
Okay, now I am going to explain about a summary journal article. So the journal article named Assault and Battery was written by Margaret Wilson QC. This is quite an old article, however, it still applied the same principle that we use until now. So this journal article explains about the fundamental principle underlying the law of assault and battery, where both in criminal and civil. So in both criminal and civil is that every person's body is inviolate. It is a basic human right to be protected from any of intentional, non-consensual offensive acts which are harmful to human dignity. And this right has always received full protections of law since a long time ago and until now. So the writer also has taken the definition from a Crampman's prayer book and Shakespeare play to interpret the words of assault and battery. So the assault is limited to threat of violence, whether it's in a verbal or gesture, and battery is the actual applications of force. So in criminal law, assault is defined by the writer as any act committed intentionally or recklessly, which causes another person to apprehend immediate or unlawful personal violence. So once force is applied, the assault has becomes battery. So an assault by itself without battery is a criminal offense. So although rarely charged, there must be a threat sufficient to cause the victim to have a reasonable fear of immediate attack. Okay, so to constitute either both of these crimes, there must be an intention to use force against another without his consent, and there must be positive act and not a mere omissions. The force may be minimal, like a push is enough, but it must be intentional and not accidental. So here again, the same principle is being used, same like what we learned today, what like we learned now. So meanwhile, in civil action of English law, writer explained that
trespass against persons was actually the basis of the action which has evolved in modern times into torts of assault and battery. So it all started with trespass against the persons and then it developed into a concept of torts of assault and battery. So the applications of assault and battery in civil law are actually similar as in criminal law. In either case, there must be intent to make unwanted contact, not merely an accidental brushing against or like friendly gesture such as such as shaking hands. So in both criminal and civil, to prove assault and battery, there must be intentions.
We have been discovered that there is actually three legal issues which has been arises in this current case, which is first, whether defendants are liable for battery, second, whether the death threat uttered by the defendant amounted to assault, and last but not least, whether the plaintiff entitled for compensation as the result of the defendant's action. And there is arguments which has been arises by the plaintiff and the defendant. As a part of the plaintiff wished to claim for damages against defendants for assault and battery. The second is because he was assaulted without any lawful reason and he does not even know any of the defendants. And last but not least, the defendant's assault has resulted to serious injuries to him. And on the parts of the defendants, they admit that they commit the action because feeling wary of the plaintiff's sudden appearance, as the plaintiff was a stranger and never be seen in the kampung before.
So now we will discuss the first issue raised in this case, which is whether the defendants are liable for battery. In order for battery to be established, there are three elements that need to be fulfilled. The first one is hostile intention, the second one is direct force, and the third one is without lawful justification. So as regard to the first element, which is hostile intention, W.D. Rollison, in the book of TORTS, Assault and Battery, has described or defined battery as a harmful touching of the plaintiff person caused by the defendant with an intent to inflict a harmful or an offensive touching either of the plaintiff person or that of a third person. So what we want to highlight or stress here is a statement of intent to inflict a harmful or an offensive touching. So this statement or these words has actually implied the necessity or the need of hostile touching to be there before battery can be established. In addition, if we want to see the view from the judge in the law cases, for example, the Court of Appeal in the case of Wilson and Pringle held that there must be a hostile touching before one action can be amounted to battery. So as long as the defendant understands that what he is doing is something that the plaintiff may object to, then hostile touching will be established. But this view of Wilson and Pringle is vague and in conflict with the view of Lord Gough from F and West Berkshire Health Authority, in which the court described or explain hostile touching as the deliberate touching of another's body beyond the bounds of acceptable everyday conduct in the absence of lawful excuse. Acceptable everyday conduct here is different from one society to another, and it even differs from one generation to another. So what amounts to hostile touching may be different based on the facts and the circumstances in one case. For example, a mere child play or horseplay between children may not constitute hostile touching because it's something that are common between the children themselves. So the latest view, which is the view of Lord Gough, was more preferable as it provides clarity. In the later case of R. and Brown, it's a case of 1993, the House of Lords stated that if an act was unlawful, it was hostile. So this case has provided a new definition of what amounts to hostile touching. It's an unlawful act. So applying this to the current discussed case, the defendant's action of pouring hot water and beating the plaintiff using hard object was clearly unlawful. Therefore, it was hostile. Even if we want to adopt the principle used by the Lord Gough in the previous mentioned case, where the court said that beyond the bounds of acceptable everyday conduct in the absence of lawful excuse, we can see here that defendant's actions were not an acceptable everyday conduct. So their actions could not be treated as mere pranks or a joke between friends. So they were clearly unlawful, therefore hostile intention is established. Second element is the element of direct force. So in general, any physical contact with the body is sufficient to amount to direct force. However, The case of Purcell and Horn has stated that contact with things as attached to the person will only amount to battery if there is a transmission of force to the body of plaintiff. So if it's just a mere touching or physical contact to the plaintiff body without transmission of force, it could not amount to battery. So in reference to the much later case, which is case of 2008, Tan Kian Ho and Poh Kian Chong, the case that we are referring to, the judge in the appeal case held that the medical evidence provided by plaintiff was already sufficient enough to prove the direct force caused by the defendant to him. So even without other evidences such as the statement by the plaintiff wife, the element of direct force can be proved or can be established by the medical evidence brought by the plaintiff to the court. I quote what the judge said here. If at all corroboration or confirmation is required, it can be found in the medical evidence and the testimony of the witness. In the current case, there is an obvious direct force, which is the action of pouring hot water and beating the plaintiff with a hard object. As a proof, there is a medical evidence brought by the plaintiff that shows that there is a burn injury and the broken finger as a consequence or as the result of the direct force caused by the defendant. Therefore, the medical evidence can be a proof of direct force and the element of direct force can be established. The next element is the last element, which is without lawful justification. So physical contact of another's body without justification of the loss could amount to battery. Lawful justification here includes lawful arrest by police, a surgeon operates his patient after getting the patient's consent, self-defense, and etc. So if the reason was not justified and not reasonable, it amounts to without lawful justification. So adopting the principle used by the judge in the case of Ng Chui Ao and another, and Ng Ah Jam, alias Ng Kim Piao and another, which was the case that we are referring to, the judge in this case held that the words uttered by the plaintiff in this case could not amount to an invitation to fight, and it's not a provocation. Even if that's the case, the violent and malicious conduct could not be justified. So in this current case, there was no justifiable reason of defendant's action towards the plaintiff. The plaintiff did not do anything prior to the accident. He had just arrived and waiting for his foster mother in front of her house. When the court had asked for the statement from the defendants, actually the plaintiff and the defendants had never met before, as the plaintiff lived in a different state or different kampung. The plaintiff lived in Kampung Pengkalan Batu, while the defendants lived in Kampung Sri Lumpur. So the defendant's action of the plaintiff was due to the fact that the plaintiff had never been seen in the kampung before, and the reason was not justified and not reasonable. Therefore, the elements of without lawful justification is established. So the defendant has actually fulfilled the three elements of battery, which is the first one, hostile intention, second one is direct force, and without lawful justification. Therefore, the defendants are liable for battery.
So second issue is whether the death threat uttered by the defendant amounted to assault. So by referring to our article, which is in Assault and Battery, the Doctor and Criminal Law by Margaret Wilson, assault is defined as any act committed intentionally or recklessly which cause another person to apprehend immediate and unlawful personal violence, which it has been outlined in the case of Fagan and Metropolitan Police Commissioner. And even in the another article, which is in Thought, Assault Battery by W.D. Rollison, an assault is also been defined as an act done by one person which causes and is intended to cause to another an apprehension of an immediate and harmful or offensive touching or contact with his person. So based on these two articles, actually there are three elements to establish assault, which is first, the defendant himself must have an intention to do his act, where some gestures and preparation to commit a battery. So by referring to the landmark case, which is in the case of Lewis and Hoover, an assault is an attempt or offer with violence to do a corporal hurt to another, as if one lift up his skin or fists at another in a threatening manner, or even in the case of Tuberville and Savage, the court held that the words if it were not assist time negativate the elements of intention to injure the plaintiff. So when we are applying this principle in our current case, the defendant's action in threatening to kill the plaintiff after beating and pouring hot water, and while even holding the knife, proving that actually the defendant has intention to do his act. So the second is the court will see whether the plaintiff felt a reasonable apprehensions of harm that the force will be inflicted upon him. So we will be referred to the case of R and George, where the court held that pointing an unloaded gun at a person constituted an assault because that person felt apprehension that the force will be inflicted upon him even though he didn't know that the gun was unloaded. So in our current case, seeing that the plaintiff had already injured as a result of the defendant assault, tried to kill the plaintiff after injuring him, caused the plaintiff to feel apprehension that a force will be inflicted upon him. In the other words, it there was a reasonable fear on the parts of the plaintiff. And last element is the court will also see whether the defendant has a capability to carry out his threat. So we will be referred to the case of Stephen and Mayes, where the court held that the assault was established as he was capable in carrying out the threat if he was not stopped by the third party a few seconds before he hit the plaintiff. So in by applying this principle in our case, as the defendant already injured the plaintiff, it means that he was capable in carrying out his threat if the plaintiff did not manage to escape from him when they arrived at Sungai Dahaka. In addition, the words to kill the plaintiff itself can also be constituted into an assault. So actually, for the issues of an assault, we didn't find a specific principle which being used in our two cases earlier. However, we found another case, which is the case of Shalini Shanmugam and Matni binti Anim, where the court outlined the principle for an assault, which the court held that words which instill a reasonable fear of unlawful and immediate violence does amount to assault, where what violence words are used followed by the violence action which cause harm, it is an assault. So in our present case, the threat uttered by the defendant after abusive plaintiff can also amount to assault. It is because there is possibilities on the parts of the defendant to carry out his threat. So therefore, the assault is established.
Okay, next, we are going to discuss issue number 3, whether plaintiff is entitled for compensation as the result of a defendant's actions of assault as well as battery. So we have concluded that plaintiff is entitled to the measures of 1, pain and suffering, the injury itself, mental distress, as well as medical expenses. So before we go further to calculate the amount of compensation that need to be compensated to our plaintiff, so we firstly need to analyze the injury that been suffered by the plaintiff. So in this case, this injury is called as scalding. Scalding most of the time happen because of a burn from hot water, and scalding fall under first degree burns. It means it only affected the outer layer of the skin and it does not affect any internal organs as well. So most of the time when we go to medical practitioner or to hospital, the first thing that they will examine is the total surface burn area of the victims. So in this case, we have estimated that the total surface body area was about 30%. So in this case, as we can see in the picture, our plaintiff has suffered from scalding on his face, scalding on his cheek, scalding on his back, as well as on the back of his head, as well as also he suffered from a broken index finger. So it is important for us to note that this is a first degree burn. So the amount of compensation is not as big or higher as compared to third and fourth degree burns. So actually, it is quite difficult for us to calculate the actual amount of compensation because we actually do not know the further status of the, whether he is still working or he is a student and etc. So the only thing that we know is that plaintiff is 24 years old guy. So in order for us to calculate the amount of compensation that need to be compensated, we have referred to several cases with a similar kind of facts, and we look at the amounts of courts awarded to the plaintiff in those cases. So for general damages, pain and suffering, burn chest and back, injuries on head and face, we have referred to case Nirmala Bonat against Yin Fat Ha and another. So the court in this case has awarded the plaintiff with 105,000 for burn chest and back, 10,000 for injuries on head and face. And for the injury itself, in our case, our plaintiff has a broken index finger. So because we could not find any cases related to our case, so we look at the compendium of personal injury awards. So so the amount that needs to be compensated to our plaintiff is 3,000 ringgit. So for mental distress, we have referred to case Ng Choi another against Ng Ajam. So in that case, the plaintiff has been awarded 15,000 for suffered of humiliation, loss of pride, and self-esteem from injury of assault and battery. So for specific damages, we have referred to the case of Abdul Ghani bin Hamid against Abdul Nasir bin Abdul Jabbar. So in this case, for instantaneous treatments as well as follow-up treatment for scarring, the court has awarded amount of 50,000 ringgit for the plaintiff. So adding up all of these amounts, so total amount of compensation a plaintiff entitled is 183,000 ringgit Malaysia. So it is not as high or as big to third or fourth degree compensations. However, I think it is sufficient enough and it is quite enough for plaintiff to use it for his recovery, because most of the time recovery for a first burn injury would take like 3 to 20 days because it is not severe as other type of injury. It is not as severe as third or fourth degree of burn, as it only affects the outer layer of the skin and not the internal organelles. So plaintiff is not entitled to damages of exemplary damages as well as loss of learning. So why we look at these two damages? Because most of the case that we refer, plaintiff are entitled for exemplary damages as well as loss of earning. However, we need to look at the category. So when the exemplary damages is awarded. So the first category is when plaintiff has been a victim of unconstitutional act of public servant or servant of the government. And the second situation is when defendant act has been calculated by him to bring him profit which exceed the amount of compensation that he needs to pay to the plaintiff. And the third situation is when there is a statute expressly authorized it. So in our case, our plaintiff does not fall under any of these three categories. So we have referred to the case of Ng Choi Ao and another against Ng Ajam, Ng Kim Tiao and another. As for loss of earning require specific need. Actually, loss of earning need to be specifically proven. However, as I said before, we do not know the further status of the plaintiff, so we could not specifically calculate the loss of earning of the plaintiff. So, as the conclusions, defendants are jointly liable for causing such assault and battery to our plaintiff, which has entitled plaintiff for compensation of general and specific damages to 183,000. So in our current case, we have relevantly applied principle of battery and assault that has been outlined in selected journal article as one of the main references. So in discussing liability in battery, we referred to case Tan Kan Ho against Poh Kian Chong. Meanwhile, in calculating the amount of compensation, Ng Choi Ao and another, Ng Ajam, as well as other related cases have been referred to as a guideline for us to determine the price of compensation that need to be paid by defendants. So I think that's all from us. Thank you.